Well, welcome in everybody. We are live with another episode of Level Up Law, where on Tuesdays at noon we are leveling up your legal knowledge about an area of law that we practice in. I'm Susan Ingalls, Consumer Law Unit Head at South Carolina Legal Services, and I am here today with our producer Kenneth Elliott. I'm going to be talking about the new CARS rule that the Federal Trade Commission has promulgated. That's going to go into effect on July 30th of this month. So a couple of weeks from now, if you're thinking about getting a new car, you might want to wait a couple of weeks until this new law is in effect because it definitely provides a lot more protections than we have currently. So welcome in. Before we get started, I do want to remind everybody that this is not legal advice. It's really just general information for the public. It's important information, though, especially about a new law that's coming out. You'll see on your screen what we call our Connect card, and you can connect with us on social media at SC Legal Services on all of these platforms. If you'd like to connect with us by signing up for our newsletter and other resources, you can scan that QR code. We'd love for you to do that and join us on all the social media platforms. I do want to also remind you that Kenneth is recording this episode as we always do, and then we'll be uploading it to our YouTube channel where we have a Level Up Law playlist with all of our other videos about different topics. You also see here on your screen how to apply for our services here at South Carolina Legal Services. You can apply online or you can just call us, either one. Our intake office is open Monday through Thursday from 9 to 6. They're closed on Friday, so that online option gives you a way to apply if you're not able to during those working hours. So again, today we're going to be talking about combating auto retail scams. That's what the CARS rule stands for. So let's just talk about that a little bit. As I said, the Federal Trade Commission issued the CARS rule. It's been about 2 years since they first started the process. So when they first put out a new rule, new rulemaking, I think they call it. That was in June of 2022. So that shows you how long it takes to get a new rule through the process of approvals and people commenting on it and saying how it might should be changed and so forth. The primary purpose of the CARS rule is to add truth and transparency to the car buying and leasing process. They want to make it clear that certain deceptive or unfair practices are illegal. So there's a lot of rules and laws out there about unfair and deceptive practices. We have an unfair trade practice law right here in South Carolina. We also have a Dealers and Distributors Act that prohibits deceptive acts and practices. But what this rule does is really makes the public as well as car dealers aware that things like bait and switch tactics, hidden charges, junk fees, all these various deceptive acts and practices that cost billions of dollars every year, not only to the consumers, but also to good, honest car dealers that are doing it the right way. So it's an important rule. You know, when the final rule came out, it was like 372 pages, right? So I must admit I haven't read those entire 372 pages, but I do know what we can expect that dealers are going to absolutely have to do. And you need to know that so that when you go to buy a car, you make sure that they're doing these things for you. It's definitely going to be super helpful, and they are taking care of some of the problems that we see very often here at South Carolina Legal Services when people apply for our help because there's been a problem with the car that they bought. Okay, so let's get into it. I do want to mention, and the FTC highlights this as well, that there are clear protections in there for the military because military is always a big target when it comes to car dealers, and even such that some of these dealers will act like they're somehow affiliated with the government or with the military, and that somehow it's going to be better to get a car from them. So I do think that's a really important thing to mention. I'd also like to mention, if you want to do a deeper dive into this, if you'd like us to do a deeper dive, please put that in the comments down below. If you're watching this on the replay on YouTube, we'll be glad to do a little bit deeper dive about some very specific things that you need to be looking for and doing when you're buying a car. But I think this presentation will lay out most of that for you. But if you want to do a deeper dive, you can go to ftc.gov, and they not only have some really good descriptions of the new rule, they also have a guide for auto dealers, which goes into so much more detail because they want to make sure that auto dealers know what they're supposed to be doing when it comes to a new customer buying or leasing a car. So first, pricing and payments. They have to tell you the offering price, and that means the full price of the vehicle, right? The kind of the off the lot price, I think we call it, means the price exclusive of government fees like taxes, license registration, and that sort of thing. So it doesn't include that. And we'll talk a minute about add-ons, because add-ons are not the offering included in the offering price. So we'll talk about those in a minute. But they have to tell you that off the lot price, and they have to tell everybody the same drive it off the lot price. So you definitely keep that in mind. Now, as far as payments, if they are themselves doing that initial retail installment sales contract and they're quoting monthly payments to you, they have to tell you the total amount that you'll pay. And if they offer you a lower monthly payment, then they have to tell you because sometimes they'll say, okay, this will be your payment, right? And you say, well, I can't afford that payment. And so they say, well, we could do a lower monthly payment. We can refigure the numbers or something. And so then they give you this lower payment. They've got to tell you under this rule if that raises the total cost of the vehicle. And quite often there is an increase in the cost of the vehicle when that's done. So keep that in mind, that off the lot price. Now here's instances when they must clearly disclose that off the lot price, that offering price, okay? And this mainly has to do with how they advertise. In an ad that references a specific vehicle, right? Whether it's expressly or by implication, right? So if there's an ad that does that, they have to disclose the offering price. Can't change it back and forth. If there's an ad that is representing a particular cost, a particular money amount, or particular financing term for a vehicle, like they might say what the monthly payment will be on this car. Okay, if they're doing that and giving you an exact monthly payment, or just implying that there's a particular payment that it's going to be, they have to clearly disclose that price. Now, if they are communicating with a consumer based on a specific vehicle or any particular money amount or financing term, in the first response to a consumer, right? You have to disclose the offering price. If it's in writing, not just talking, if it's in writing, the offering price has to be disclosed in writing. Okay, I mentioned add-ons, okay? What is an add-on? And you'll note at the bottom of the slide, the rule defines an add-on as any product or service not provided to the consumer or installed by the manufacturer that the dealer directly or indirectly charges the consumer for. So here's just some examples of these kind of products. And, you know, the neat thing is that they have to tell you that you don't have to get these products, that these aren't part of the overall price, and you don't have to get any of these products or services. So, you know, some of the examples given are rust proofing, some kind of protective paint. They sound familiar, right? Extended warranties. You know, most cars carry a warranty to begin with, but then they want to sell extended warranties or service agreements, which are um, sometimes referred to as warranties, but it's different from that when it's a service agreement. Gap coverage, that guaranteed asset protection agreement. Specific separate wheel and tire warranties. All of those are add-ons, right? And also, and I think this is really great, they can't charge you for products or services that have no benefit to you, like a warranty that's a duplication of a warranty that you already have. I love this one. A service contract for oil changes on an electric car, right? You know, you don't need that unless it's a hybrid, of course. Nitrogen-filled tires. This is one that is sometimes offered. And nitrogen-filled tires that contain no more nitrogen than normally exists, you know, in the air, right? And then a gap agreement that doesn't really cover your vehicle or your neighborhood or other parts of the deal. Okay. So it's really important to understand about those add-on products because they always sound really important, but you have the right to refuse them, and now dealers have to tell you that that you can say no. Okay? Okay, they have to get your real consent for all these charges, right? They cannot charge you for an item unless they've told you specifically what it is and how much it costs. And they can't charge it if you've not specifically agreed to that charge after getting the explanation. Okay, so it's going to be, as the FTC says, a lot easier to shop around for a vehicle based on the actual price of it. And the Federal Trade Commission is estimated it's going to save $3.4 billion per year. So it's really an exciting change. And I did want to add, what is, you know, your express or your informed consent? Well, this rule defines that. There's a lot of definitions in there, but I think this is an important one. That means an affirmative act communicating unambiguous assent to be charged after receiving and in close proximity to a clear and conspicuous disclosure in writing and also orally for in-person transactions of the following. What is the charge for? What's the amount of the charge, including if the charge is a product or service, all fees and costs that are going to be charged to the consumer over the period of repayment with that service and without that service. So I think that's really important. And they do give some examples in the rule of what might be express informed consent, okay? Or not express informed consent. A signed or initialed document by itself. Now, lots of dealers have done this over the years. You'll get that one sheet and it has however many statements on it, 10 or 15 statements on it with a little place for you to initial, right? And they go over that really, really quickly. But if you ever have a lawsuit that's involving a car purchase, they always use that document to show that you consented to what you're now suing them for. And so then you have to, you know, prove that you weren't really giving your consent because of the way that it was presented to you. But now, just initialing a document with a bunch of statements on it is not that express informed consent. Pre-checked boxes where, you know, they hand you a piece of paper and they've already checked all the boxes for you. And then an agreement that is obtained through any practice that is designed or manipulated with the substantial effect of subverting or impairing user autonomy, decision making, or choice. That is pretty inclusive of a broad range of things that is often done or are often done by car dealers. So, you know, that express informed consent is going to be really important going forward. So I wanted to just give this little laundry list because I think it's a good one and it's a lot, but it's great for people to realize how many things there are that can be misrepresented by a car dealer. And this comes from Section 5 of the CARS rule, where they specify that these are things that are illegal for dealers to make misrepresentations about. And of course, it has to be material misrepresentations. Okay. The costs or terms of buying, financing, or leasing the vehicle. Okay, you cannot misrepresent any of that. Any cost, limitation, benefit, or any other aspect of an add-on product or service. Whether the terms are or the transaction is for financing or for a lease. You know, sometimes you don't realize that what you did was actually lease a car instead of buying it. The availability of any rebates or discounts that are factored into the advertised price, but not available to all consumers. Okay, that's information they cannot misrepresent to you about. The availability of the vehicles at an advertised price. You know, quite often you'll get a mailer from a car dealership and it talks about these great prices, but then when you go to with your flyer to that dealership looking for that particular car, suddenly, oh, we're all out of those. That's not available. Well, let me show you some other ones. Okay, so that's kind of an advertising ploy to get you to the dealership, but not give you that great deal that they've been publicizing. Whether any consumer has been or will be pre-approved or guaranteed for any product, service, or term. So when they're saying, oh yeah, we can get you that car for that price or for this monthly payment or whatever, they cannot lie about that. They cannot misrepresent those approvals and those guarantees. And this is what, we often see in yo-yo sales where they say, oh yeah, you're approved, everything's cool, and then you drive off with the car and they call you to come back and say, oh gee, that financing didn't get approved. Well, you've already signed for it, right? So I think that's going to help with those kinds of situations. Misrepresentations about any information on or about a consumer's application for financing. The application that you sign is so very important. It's important for you to tell the truth on it. It's important for you to read it when you sign it and make sure that you get a copy of it as signed. And these days with all the iPad signing and the computerized signing, sometimes that's hard to do, but you need to have a copy. Right? You need to have a copy of what you signed when you signed it so you can make sure that nothing is added or deleted after you make that application. Let's see. Oh, and again with the yo-yo thing, no misrepresentations about when the transaction is final or when it's binding on all parties, both the seller and the buyer. Okay, you can't say, oh yeah, this is we're good, we're all done, and then you're not really all done, right? So let's see, keeping cash down payments or trade-in vehicles, charging fees, or initiating legal process or any action if a transaction isn't finalized or if the consumer doesn't wish to go forward with a transaction, right? So if they have given a cash down payment or they're providing a trade-in and that kind of thing, no misrepresentations about the finalization of the deal, right? Okay, whether or when a dealer will pay off some or all of the financing or lease on a consumer's traded vehicle. This is a problem that we see when people think that they're trading their car in, and whatever they owe on that car, if they still owe something, is being covered, and then it's not, and all of a sudden they realize that they're still supposed to be paying on that trade-in vehicle. And then maybe whoever you traded that car into is saying, oh yeah, no, we weren't paying that. We're not responsible for that. You initialed right here and said we weren't doing that. You just never know. So I think that's a really important misrepresent or area of misrepresentation that you could see. Okay, here's another category: whether consumer reviews or ratings. Okay, you cannot misrepresent about those. Are they unbiased? Are they really independent? Were they ordinary consumer reviews or ratings of the dealer or the dealer's product or services? So they can't misrepresent about who's saying how great they are, right? And how wonderful they are to their customers and things like that. They can't put out information about that that's not true. That's a misrepresentation. And so that's going to be some changes, I think, involved with that for sure with some of the dealers that we see. Okay, whether the dealer or any of the dealer's personnel or products or services is or was affiliated with, endorsed or approved by or otherwise associated with the United States government or any federal, state, or local government agency, unit, or department, including the Department of Defense or any branch of the military. This is crucial because we see so many of our wonderful folks from the military and their families who can get into a real mess with car dealerships because it's been misrepresented or suggested that somehow this is connected with their service in the military and it makes it somehow a better deal, or just that they're connected with the military or the government. Just that misrepresentation alone may be sufficient. So that's really important. Here's another category. You can't misrepresent whether or not the consumer has won a prize or a sweepstake. You get those flyers in the mail too that you've won a prize, or scratch off here and see how much you get. They can't misrepresent that. Either they're giving those prizes or those sweepstakes, or they're not. Whether or under what circumstances a vehicle can be moved, whether it's across state lines or out of the country. Whether or under what circumstances a vehicle may be repossessed. One of the things we see quite often is you do have to keep your car insured in South Carolina, right, to a certain minimum level. Lots of times we see people change their insurance and you got to notify whoever is your lender on the car, right? And let them know that you've changed so they'll know that even though they see a cancellation notice of a previous policy, that you have a new policy. So you've got to make sure that they know that. But sometimes they will just pretend like they didn't get your notice and they will repossess your car and say that it was because you did not have proper insurance. So that's one of many ways that they can say your vehicle should be repossessed. Obviously, another one is not making your payments. But when you are buying that car, they cannot misrepresent to you the potential factors in a repossession. And then there's just this final category that's a catch-all for everything, which is wonderful. And that is any of the disclosures that are required by this rule, which is a lot. You cannot misrepresent any of those disclosures. So that's a great list and a great way to think about all the things that can happen and all the ways that a dealer might misrepresent things to you. Okay, here's just a little recap. I got this flyer from the FTC from their website, and this is from their dealer's guide. So it says that it protects the consumers and the benefits, and it benefits honest dealers. So let's just do a quick review. Number one, it prohibits misrepresentations about material information. Number two, it requires dealer to clearly disclose the offering price, the actual price that anyone can pay to get that car, excluding only basically those tax tags and title. Number three, makes it illegal for dealers to charge consumers for add-ons that don't provide a benefit. And then four, it requires dealers to get a consumer's express informed consent before charging them for anything. And we went over what that express informed consent is. So next time you go to buy a car, you might want to review this and know that anything that you're told, anything that you're signing, they have to get your express informed consent for these things. So again, for any further deep dive into this topic, you can go to ftc.gov and just put in the CARS rule, and there's plenty of material there for you to kind of review. And of course, again, we will upload this video to our YouTube channel on the Level Up Law playlist. Kenneth will do that for you. And also, of course, just remember, this is how you can connect with us here at South Carolina Legal Services. I'll leave that up on the screen for just a minute while I remind everybody that we appreciate your attention and your registering for any and all episodes of Level Up Law. We have over 166 or 7 episodes at this point, and you might think we've covered it all, but as this episode shows, there's new laws happening all the time. There's nuances to laws that we already have, so we do try to bring those to you. Feel free to comment on any of the episodes that you find on our YouTube channel. We hope that you find them helpful. Here's another helpful episode that we rescheduled from earlier this back in the spring or early summer, I think, and that is It's Just a Civil Matter. That's our next episode next week on July 22nd, Tuesday at noon. That's next week. We'll have Emily Miller. She is an attorney in Michigan who is works in the area of domestic violence, and particularly elder domestic violence. And she will be talking about that being a civil matter. You know, quite often the police are called when there's violence involved, and it's a criminal matter, but it's also a civil matter. Sometimes we go to the police about something and they say, oh, that's just a civil matter. Sometimes clients come to us and we say, oh, well, that's a criminal matter. So Emily, who worked for us many years ago, and we really miss her here, but I saw her back in May, I guess, at a conference. And so she agreed to come on the show and talk about how it is just a civil matter and all the ways that you can get help when it comes to domestic violence. So definitely tune in and keep an eye out, and we'd love to hear from you. We appreciate you being there in the audience today and every Tuesday when we have Level Up Law. So thanks, everybody. That concludes today's webinar. Take care.